Good morning, good afternoon, wherever you are in the world. My name is Peter Ashford, and it's my privilege to host this webinar this afternoon, London time. There's quite a few people still logging on, so we'll give it a few moments for the numbers to stop rising in the now time-honoured fashion. Just again, for those logging on who wonder why nothing's happening, we are waiting for a few more people to log on. Give it another minute or so. The numbers are still rising fairly rapidly. Well, I think they're stabilizing a bit, so now is as good a time as any. Again, welcome. My name is Peter Ashford. I'm partner and co-head of International Arbitration at Fox Williams, and it's my pleasure to welcome you to this webinar. It is being recorded, and there is a Q&A function at the bottom, so if you have questions, please put them in that, and I will endeavour to monitor that. It's my great pleasure to host this webinar on the concept of memory in witness statements. April 2021 saw the implementation of the recommendations of the Witness Evidence Working Group, reporting to the Business and Property Courts Board with a radical approach to the gathering and content of witness evidence. Similarly, in 2020, the ICC Commission reported on the accuracy of fact witness memory in international arbitration and cautioned on the reliability of witness evidence and made recommendations for future practices. In this webinar, we are looking at the psychology underlying both reports, what was wrong with the witness statement system, and will the recommendations see an improvement. We are not going to look at the detailed provisions of Practice Direction 57AC. I'm sure that will disappoint many, but that's what we're doing. The general point is that assuming that they are not forgeries, documents do not lie. They might not tell the whole story and may need some supplementation by oral testimony, but they are generally the most reliable source of truth. And the famous critique of factual witness oral evidence is that of Mr. Justice Leggett, as he then was, in a case called Gestim and Credit Suisse. And he said the following: place little, if any, reliance at all on witnesses' recollections of what was said in meetings and conversations, and base factual findings on inferences drawn from the documentary evidence and known or probable facts. That and much more of the judgment has been cited with approval on many occasions. Witness statements are at least supposed to be a reflection of a witness's recollection or memory of the events that they can speak to. That was often not the case. Rather, they were lawyer-crafted aspirational accounts of what the lawyers would like the witnesses to say. The lawyers ensured that the witnesses spoke to events about which they may never have been involved in, and even if they were, had little or no recollection of. The result was overly long, largely inadmissible accounts where the witnesses appeared to recall events with the utmost clarity. Not only that, but when they professed to recall something, how reliable was that memory? To discuss these and other matters, I am joined today by Dr. Kimberley Wade of Warwick University. Dr. Wade did the research underlying the ICC Commission Report. Essentially, most of the academic research at that stage had been restricted to criminal matters, and Dr. Wade did the research to indicate whether or not that was to carry over also into the commercial sphere. John Kimbell QC was a member of the Witness Evidence Working Group, but speaks today, I'm sure, in his personal capacity rather than a member of the group, just to avoid any issues there. He is a member of Quadrant Chambers, busy commercial practice, and also sits as a Deputy High Court Judge. And finally, but by no means least, you will, I'm sure, all know Lord Neuberger, former President of the Supreme Court, who needs no further introduction. Kimberley, can I come to you first with the question, is memory fixed or does it change? If it does change, how and why does it do so?
Absolutely. Thank you, Peter, for inviting me today. So, of course, we all want to believe or like to believe that our memories are permanent and they're fixed and they're accurate representations of the past. But around 50 years of research, even more, shows us that that's really not the case. And errors in our memory can be for minor details of events. We can even have memories of wholly false experiences that we've been personally involved in, of fairly substantial and important events in our past. And a lot of people don't really understand why this is the case. And I like to tell people that memory errors actually do serve a function. They're not just some sort of artifact of an otherwise powerful memory system. They do help us socially, they help our well-being, and they have many other purposes. But memory distortions basically happen because our perceptual systems aren't set up to actually encode all of the information in our environment. So our memories are sparse, they have gaps. And when we retrieve information from memory, we construct a memory. So we take fragments of information that we've encoded and we combine that with other information that we've gathered, gleaned from other sources. So in the case of a witness, for example, their memory could be a combination of actual events they've encoded, but also information that they've gleaned from another co-witness through a discussion, or perhaps through something they've seen in the media, or perhaps through the minutes they've read or an email they've received from a colleague, and so on. And one of the problems or the challenges, of course, is that we don't always know what information is in our memory and what the source of that information is. And unfortunately, our memories don't come labeled with these instructions that say, well, this memory is based on a real event, and this memory is based on something that Thomas told you. This memory is based on something you saw in the media. So every time we have a memory, we have to decide what the source of that information is. And we do that rapidly, automatically, without any cognitive effort. We do this without any awareness. It's a decision-making process. And because it's a decision-making process, sometimes we get it wrong. And so some information we recall, we think is based on a genuine experience we've had. But in fact, that information could be from something you received after the event happened. Or it could be based on your own expectations, your motivations, your goals, other cognitive biases that feed into this remembering process. Another challenge with memory is that we all like to think we know how memory works, but in fact, the research shows that a lot of people don't have a good understanding of the factors that influence our memory. So most people, I think, understand that a leading question can affect what a witness recalls, but most people don't understand how our own motivations, our own perspective, how things like emotion, hypnosis, age, all of those factors can affect memory and how we remember as well. And so I think it's a good thing for those who are involved in legal decision-making to actually have a basic understanding of some of the main factors that do influence what we recall, especially since these factors happen without our awareness. It's important to kind of get a better understanding for that in any context in which you're trying to glean accurate information from a witness. So not just in civil law, but in all sorts of investigative practices, in criminal law, and so on. So hopefully that gives you some sort of background of the psychology of why we have memory distortions.
So the frequency and the manner of accessing the memory will change it. So the more we do it, the more it's influenced to other things, and how we access it in terms of the questions that we ask and things like that. They will
Absolutely.
all change. Yeah.
Well, every time we access a memory, there is a chance for further reconstruction. Because it's the process itself of recalling an event is reconstructive. That doesn't mean that every time we reminisce about a memory that it's going to be more and more or less and less accurate, but there is potential for it to change every time. We can't carry on believing that a memory is fixed and that once we've described it, it will always be that way.
Thank you, Kimberley. John, can I come to you now? And the Witness Evidence Working Group concluded that evidence elicited orally in the courtroom surroundings is often more reliable than the witness statement. Was that because the evidence has been changed, at least in part, by the manner of its collection and presentation in the form of a witness statement?
Thanks, Peter. Yes, the short answer is yes. That was the view that the working group formed. I'm afraid to say it didn't reach that view, having read lots and lots of scientific papers, I'm afraid, Kimberley. But I can tell you what the origin of the main thrust of the report was, and it's a slightly curious one, and it arises from the fact that the project itself started in the Commercial Court in London, and one of the odd features of the Commercial Court is that the judges there don't just hear commercial cases, as is the position in many countries, but those Commercial Court judges also go out and hear very difficult, high-profile criminal cases. But they're not appointed from the criminal bar. The background of most Commercial Court judges is the commercial legal profession. Either they're leading commercial solicitors or they're leading commercial barristers. And many of those judges have therefore, in the last 25 years since witness statements were introduced in 1986, haven't ever seen old-fashioned examination in chief. They have instead received and seen very long witness statements prepared by lawyers, 150 pages long sometimes. And so when they're appointed to the Commercial Court, sometimes a little bit before, they go out and sit in a criminal case, and for the first time they hear real evidence in chief, just how the witness remembered it. So they were confronted with this great contrast, which was, on the one hand, you've got what they've been used to for 25 years, which is long, carefully crafted, polished witness statements purporting to tell the story from beginning to end. On the one hand, that's their commercial experience. On the other hand, they suddenly see real life, up front, really up close and personal, witnesses failing to remember anything, failing to come up to proof even, because they just can't remember anything, or they can't remember the thing that they've been called to give evidence about. So what the report was basically saying is that what started life, the memory of the witness, it started life, it seems to us, as a nuanced patchwork of partial memories, some quite clear, others completely unclear, and hedged around with a lot of uncertainty. That's what comes up quite often in the Crown Court, sometimes to the extent that the witness doesn't come up to proof at all. And yet what ends up being produced, and now has been produced until very recently in the Commercial Court, is something quite different, which is a beefed up, fully polished product, which doesn't accord with reality. So the main aim of one of the main aims of the reforms and the conclusion that we reached as a group was to try and get back to that more nuanced picture of what a witness actually remembers, and the way to do that is to change the way that the witness's statement is collected in the first place, and what is done to it before it's presented in court.
There's quite a difference between a pub brawl situation and your typical commercial case, which is already very document heavy. One assumes the pub brawl doesn't have much in the way of documents. It might have the odd WhatsApp message of, let's go and give him a good kicking or something. But does that make much difference to the overall picture of evidence?
To be honest, no. I mean, my own experience is partly, obviously, my practice as a commercial practitioner, but also sitting as a recorder in the Crown Court. If anything, that they're coming closer together. There is very rarely now a criminal case, even the simplest. I mean, I was dealing with a simple assault the other day, and we had a jury bundle with all the WhatsApp messages that have been passing between the various people involved, and CCTV footage. So documents of a kind, but yes, not memos of meetings. But then there are also very highly sophisticated frauds that are tried in the Crown Court. So in fact, the difference between the two isn't that great. And similarly, there are some commercial court actions where sometimes involving parties where they have deliberately not created a paper trail. So the issue is who's telling the truth, which oligarch is telling the truth about a particular meeting, and they will have made sure that there aren't any documents.
Yes, deliberately so, and perhaps neither of them are telling the truth, the complete truth. Lord Neuberger, if I may turn to you, you said in a 2016 speech, all fair-minded judges know that they will sometimes believe a liar and disbelieve an honest person. So far as facts are concerned, even in a very simple factual dispute, it can be very difficult to know whom to believe. Indeed, in some ways, it is particularly difficult to resolve evidential difficulties where there are no contemporary documents and only one issue of fact upon which the parties differ. Presumably, those difficulties are exacerbated by the real truth being hidden behind lawyers' craftsmanship, or some might say gloss, in a witness statement. How does the judicial mind unpick the real truth in the sort of no contemporary documents case?
Often with great difficulty. A judge who thinks that he or she can tell a truthful witness for a liar is deceiving him or herself. First of all, as Kimberley Wade's very interesting address showed, people deceive themselves unintentionally. So the fact that somebody may not be telling the truth doesn't mean they're lying. They're merely telling the facts as they remember them, and particularly after they've been quizzed and quizzed by lawyers and lent on by the party who's calling them, coupled with the problems that Kimberley's identified, their evidence is likely to be fairly unreliable anyway, but not because they're lying. Quite apart from this, if you do have a lying witness, consistently the research shows that everyone, including, I regret to say, judges, are not particularly good at telling truth tellers from liars. So relying on the impression the witness makes, I think, is not merely unhelpful, but actually dangerous. Where you've got documents, and that's why George Legate's judgment is so, what he said is so right, you place a great deal of weight on the contemporaneous documents. You have to be careful doing that, of course, because some people craftily prepare their documentation even contemporaneously, but in principle, it's far more reliable. If there is no documentation, then it's an awful thing to say because it sounds like the counsel of despair, and it is. You have to do your best, but you are likely to be influenced by subconscious factors, which are quite dangerous. Early on in my judicial career, I found myself wanting to believe a witness whose evidence was looked at objectively, not at all convincing and inconsistent, but I was wanting to believe him. And I suddenly realized that the reason I was wanting to believe him was because he reminded me of my father, who'd recently died and of whom I was rather fond. And I realized that that sort of subconscious factor plays around in your mind. On this occasion, it bubbled to the surface because I was quizzing myself as to why I wanted to believe this guy when his evidence was pretty dubious. But I think those are the sort of factors you have to be careful of. But normally, by definition, you're unaware of your unconscious biases. I think you have to fall back very often on whose story seems inherently more likely. Sometimes that is all you've got. And then, of course, you hit a problem if you're doing a case, for instance, what John Kimbell referred to, Russian oligarchs. what is inherently likely for a Russian oligarch is not something which an English High Court or other judge is likely to have a great feel for. And when you're deciding whether somebody is a genuine and asylum seeker from a country in the middle of Africa, you have no feel whatever as to whether what is being said is likely to be true. But even likely to be true is difficult. I think the two most difficult cases I had to decide as a High Court judge were when I was out in Birmingham and my commercial case collapsed. And I offered to hear two fast track cases, each of which was likely to last half a day, and went into court sort of swaggering in, this was easy stuff. And in each case, I was faced with a decision. In one case, was the light green for one way and red the other, or red one way and green the other, with no forensic evidence or crash scene evidence to help. Each driver having a witness who swore blind that the person he or she was with went through a green light. And the other question involved whether a light was on or the bulb was broken when somebody tripped in the common parts of a block of flats. And deciding in each of those cases who to believe I was almost reduced to tossing a coin. But in the end, I found myself falling back in disbelief and self-contempt on who presented better in the witness box, whose evidence was more consistent with their witness statement. But that really was the counsel of despair. But sometimes it's all you've got to go on. But just end with one thought. Early on in my career, I argued a case in front of a circuit judge, and he had my opponent and me back for a cup of coffee. And he said something I always bear in mind as a judge. You're often going to disbelieve somebody who's actually telling the truth, or if not often, it will happen. Don't find that they're lying or deliberately misleading you unless you absolutely have to. It's bad enough to disbelieve somebody who's telling the truth. To brand them as a liar when you don't have to is more than is decent. But it is a problem, and I'm not sure witness statements, for the reason John has told us and Kimberley has told us, help very much in identifying actually the truth.
Thank you. Yeah, yes, I tell our junior lawyers, our trainees, that the real skill of a disputes lawyer is telling a good story. You take whatever the client has given you and you try and spin that into a persuasive and coherent narrative. And that's essentially what we do. And to think that we've spent years studying law and reading law reports and doing things, they get very disappointed when I tell them, no, actually, the real skill is to try and tell a story in a persuasive and coherent fashion. That always seems to me to be the lawyer's craft in a disputes law. Kimberley, can I come back to you on the ICC report, which reflects at least forms of bias, the witness being exposed to a biased account or the tribunal cognitive bias. How do those biases work in each case?
Well, let me perhaps just outline what we did briefly in the ICC study to describe the sort of biases I think you're referring to there. So in our study, we asked around just over 300 people working across many different industries to read some materials, a scenario about two companies that entered a contractual agreement, and that eventually led to a dispute and they entered into arbitration. So our participants read about this scenario. They read a contract and a purchase order and other very realistic but fictitious materials. And we asked our participants, some of them we asked them to actually imagine that they were the managing director of one of the two companies in this dispute. And other participants weren't asked to imagine anything at all. We also exposed some of these participants to some misinformation after they read about this scenario. And that misinformation came in the form of a biased memo from the in-house counsel. And so our participants read this information, they imagined they were managing director or they didn't, and they were exposed to some misinformation. And then we finally gave them a memory test and we asked them what they remembered about the original events that unfolded. And in particular, we asked them about facts that were central to the dispute. And what we found is that the people who were exposed to this biased memo were 20% more likely to give a memory report that actually supported their own company's case, the case that they were asked to imagine, sorry, the company they were asked to imagine they were managing director of. Merely asking them to imagine that they were the managing director changed their responses as well. So they were 15% more likely to give a response that better suited their own company's case if they thought they were a manager of the company. And if you combine those suggestive influences, we found that they were 30% more likely to respond with an answer that better suited their company's case. So there are decades of studies like this that have been conducted in the criminal law context, but as far as I know, this is the first study to show these sort of memory biases in a commercial setting. So what happens, as I said right at the start, is that when we recall information, we use our own expectations about the world, our goals, our beliefs, all of the knowledge that we have in order to construct those memories. And so I think certainly in the arbitration context, we have to think very carefully about perhaps what a person's loyalty and perspective when they're representing a party, how that influences how they recall an event unintentionally. And of course, witnesses may be exposed to the party line. That could ultimately influence how they respond and how they recall information. The trouble is, of course, these influences happen, as we've already said a lot here, and without any conscious awareness. So it's really, it is hard to pick up. And I'd like to go back to something that Lord Neuberger said earlier about falling back on ultimately how a witness presents and making a decision based on how a witness presents, perhaps in how confidently they present and how detailed they are. There's a growing body of research that shows us that how confident a witness is not a good reflection of how accurate their memory report is. And so you can have a very highly confident and detailed witness who can have a spectacularly erroneous memory report. Generally, on the whole, the relationship between a witness's confidence and their memory accuracy can be quite good. But the moment that they are subjected to any suggestive influences, when their memory has been tainted, that relationship falls apart. So you cannot use a witness's confidence and detail as a proxy for determining how accurate and reliable they are. And I think this is the nuance that can be often missing in the argument about confidence and accuracy in a witness's memory report. It's important to understand that that relationship just disappears when a witness has been misled. And so this is probably one thing I really want people to go away understanding from this as well. That, you know, we use all sorts of things to make a judgment about a witness, and how they present can be very dangerous, as Lord Neuberger also said.
Thank you. That reminds me, and there's a question in the chat, which perhaps I'll try and turn into a question now, about to the extent in international arbitration practice, we're going to have a growing trend of orders about how witnesses are treated. And I remember a case I was involved in a few years back, where it was an arbitration seated in London under New York law. So we had New York lawyers, and they have a very different way of approaching witnesses to an English lawyer. And I said, we should have a level playing field. We should all play by the same rules. I can't play by New York rules as a matter of my professional obligations. So they're going to have to play by my rules. Well, it wasn't quite my submission, but that was the substance of it. The tribunal, in fact, did say, yes, you cannot prepare a witness in a New York style. You can only do what is permissible under English law, because we are an arbitration seated in England, and the procedural law broadly applies here. So that was very interesting. I wonder whether anyone else has had any similar experience or comment on that?
I think the fact that you have advocates from different jurisdictions with different professional conduct rules can make for an unlevel playing field and for misunderstandings in international arbitration. And it is essential that they are ironed out at the beginning of the case with appropriate directions, appropriate procedural orders. But it's easy to say that one party is going to be rather cross at the directions that you give. And if, for instance, you were to say that the lawyers can do what the American lawyers do, I would have thought it's very probable, but John will probably be able to say with more confidence than me, that the English lawyers would still not be able to do that because it's contrary to their professional conduct rules. So you can argue that what you would have to do is to have the strictest of the rules where there is a conflict.
Well, the other alternative is you just have to let both parties do their own thing, and the tribunal just has to do their best to balance it all out. And I had an arbitration where I was representing the English party and the other, and there's a German solicitors on the other side in front of a Swiss tribunal, and the German solicitors were appalled at the witness statements that we had produced. We produced perfectly normal 25-page witness statements, telling the truth, cross-referred to the documents. They just couldn't believe they regarded those witness statements as nothing short of a fraud on the arbitration. But and I really don't think there was anything that the tribunal could have done at an earlier stage to either make us do our witness statements any differently, or to make the Germans believe that actually we weren't fraudsters. But the tribunal just let us get on with it, and they evaluated the evidence from both sides in an entirely fair way, and both sides, I think, felt that justice has been done, and at least that they had a fair hearing. So I think it's very, very hard to try and find some middle way, or to go to either to the most strict or to the least strict. As a rule of thumb, it's probably better just to let both sides do their own thing.
Yes, but I can see a potential battleground, as Lord Neuberger said, that we're going to have a fight over this. Perhaps if nothing else, at least if it comes out at an early stage that I am going to do my witness statements in this fashion, that is what I am going to be doing. At least everyone knows, and there is no surprise, and that's probably better. So I think that at the very least, even if there's no direction made, having it out at an early stage rather than after the event, because sometimes after the event there's a rather sort of faux, oh, I'm terribly offended by this because it's actually rather good. So I'll pretend I've got some real grievance about it. Good. Lord Neuberger, I was going to come back to you, if I may. Another speech, I'm afraid, that you made. Somebody has read all these things you said in time 2015. It was me, actually. I read them. But you said, if our natural propensity to accept information as true depends in part on the desirability of the consequences, we must be careful. After all, the daily task of first instance judges involves evaluating such information in circumstances where they know all too well what the consequences of a particular finding will be. Judicial cognitive bias is well documented. How can we aim to reduce or eliminate it? Is it education and training in judge craft?
Yes, I mean, I think, first of all, you will never eliminate it. It's part of the human condition. The danger of trying even to reduce it is that you make the judge so self-conscious that he or she is concentrating on whether they're biased or not, and whether there's some aspect of the evidence or the hearing or the characters who are giving evidence which is wrongly influenced them, that they take their eye off the main ball. But I think attempting to make judges aware of their biases is worth doing, but it's a very easy thing to say. It's a difficult thing to do. Certainly, the papers I've read on research and subject entirely confirm what Dr. Wade said, which is the more confident a judge was about his ability to identify a liar from a truth teller, the more unreliable he was likely to be. And I entirely agree that when one's judging two witnesses on their demeanor, I tended, if anything, to favour witnesses who were rather less sure than ones who are more confident. But even that is, of course, not a particularly reliable guide. But coming back to your question precisely, I think that judges do have to be self-aware. They should be suitably aware that they are going to get things wrong. They should be suitably aware that they do have biases. And I think there are various courses, some online actually, which are rather chilling when you do them to make you realize what your biases are. But I think they're well worth doing. And I would have thought that one of the functions of the Judicial College, which educates judges and gives them continuing education, is to ensure that they are taught about biases and given some help as to what their biases are and what they should be careful about. On the one hand, I think it's the sort of training you have to do regularly, otherwise its effect fades away. On the other hand, as I say, if you overdo it, you may reduce the judge to a quivering mass of self-doubt. So you have to tread a middle line, I think.
Wise words, I'm sure we'll get there. Let's, John, can I come back to you? The Witness Evidence Working Group did not seemingly consider those issues of bias, and assuming it did not, what's your own experience as counsel and as judge?
Well, that's a two-part question. I mean, the first part, it is true that the Witness Evidence Working Group didn't consider the broader range of judicial cognitive biases, but it did take account of two in particular. The main one is the misperception that we have about our own idea of what memory actually is. Which Dr. Wade has commented on, because many lawyers and many judges still tend to think of memory as if it were some sort of video recorder in our head, which simply takes in sense data, records it, and when we're asked what we remember, we just press the play button and it comes back, and you can keep on doing that. And the general view is, well, over time that fades, but there's a model of memory as a tape recorder, a video recorder, and it was in part the recognition that was a bias that we have, a misperception about our own memory that informed quite a lot of the work of the group, and that is why what we were saying is we have to have rules for the creation of witness statements that don't fall into the trap of thinking of memory in that way, but instead appreciate that memory is much more fragile, much more malleable, can be influenced not only by what was said or done at the time, but afterwards, and all the sorts of things that Kimberley has talked about. So that was one cognitive bias or misperception that the group was very much aware of and informed its thinking about the rules. And the second is another one that Kimberley mentioned, which is the strength of a witness's own view of their reliability is almost worthless. And in that respect, I think it's appropriate in the 20 years since 9/11 to refer to the Hurst and Phelps paper, where almost immediately after 9/11 happened, they decided to go out and interview people and ask them to record what they thought, where they were at the time and what they remembered, but also to remember one other thing that happened that week. And then they went back and asked the same questions. I think it was 9 months later, 11 months, 25, and then a 10-year follow-up. And what is amazing and what comes out of the research is that the accounts change. So every time you access your memory, it slightly changes. You're retelling the story. You're not pressing back the video recorder. You're retelling it, and they become more and more inconsistent over time. But what doesn't change is how sure the witnesses are about it, or how sure the people involved were. And that's in part because we have flashbulb memories where we were at the time 9/11 happened. Almost all of us can remember that. And because we can remember that, it makes us think that we're accurate about all the other things that were happening at the time, and even about the event themselves. Anyway, so that is and the way that the Witness Evidence Working Group dealt with that was to say, well, look, we can't trust witnesses to score themselves out of 10 as to how good their memories are. All we can do is try and keep hold of what was there at the beginning, which was this nuanced, hesitant patchwork of memories, and at least try and reduce the outside influences by ensuring that, for example, there's an early proof at an early stage, and then that is you have as few iterations after that from between the proof and the final witness statement. So those are the two misperceptions or cognitive biases that we did deal with. But the second part of your question was, what's my experience? Well, I have to say, as counsel dealing with this, it's all rather crude. I'm afraid I just ruthlessly took advantage of every possible bias going on the tribunal. If you're appearing in front of a tribunal you perceive to be favourable to owners, you present your case in a way that it would appeal to a ship owner, someone from a ship owner background. So remaining within the confines of what is professionally appropriate. So as counsel, to be absolutely honest, I just ruthlessly took advantage of every possible cognitive bias that there was. But it's interesting, as a judge, completely different. And going along to the Judicial College training, I don't think I'm giving away a state secret of the Judicial College when I say that a third of the training and the judge craft is on cognitive bias. And it is a real eye-opener at just how biased you are and things that you're not aware of. And you're given quite a few bits of assistance after the course. Probably the most important thing is just to keep quizzing yourself. Just check yourself when you feel that you think, oh yes, I can assume this or that. Even about the simplest things, language. So one of the things you go away with from the course is the Equal Treatment Bench Book. And that is an amazing resource just for checking things. So to give you an example, use of language, we might assume it's absolutely natural to, when you're given a question, which is a closed question, the answer is going to be yes or no. But there are some cultures, some languages where there aren't even words for yes or no. And instead, or culturally, it's not normal to answer a question directly with yes or no. You first of all say, well, in answer to the question, you asked me this and this, and then at the end you come to. Now that might be perceived as evasive, not being straightforward. In fact, in some cultures, that's exactly how it is. So the training equips you just to check yourself and say, hold on a second, before I say this person has been evasive, let's just check what the background is. And so I think probably the answer is, as what Neuberger said, it's training and repeated training. It's not enough to go and watch the videos that Dr. Wade's colleagues produce. As interesting as they are, you've got to be able to implement it in everyday judging. And for that purpose, I have to say personally, I found the Equal Treatment Bench Book to be a fantastic resource, which is constantly updated on the web.
Very interesting to hear that, what has been happening at the Judicial College, because when it started, around the time I started as a judge, they concentrated so much more on teaching judges substantive law, which was ridiculous because you forgot the lectures and 10 years later you got the case that raised it. But teaching judgecraft and that sort of thing, and particularly things like unconscious bias, that seems to be a very great improvement.
Well, what are we going to do for poor old arbitrators who don't get any of this training and are out there deciding it's okay for the retired judge, with greatest respect to Lord Neuberger, but there's many of us who just sort of stumble blindly into the world of sitting as arbitrator without the benefit of those sorts of training. Should there be a arbitrators college or something? Perhaps that's a takeaway we can do something with another day.
Well, there are institutions, and I suppose if you could start introducing courses and making it more acceptable for people to say before they appoint an arbitrator, have you been on this course? That might be the way to deal with it, but that may not be practical, I don't know, but it's certainly an idea worth considering, I'd have thought.
I'll give a shout out for all courses run by the Chartered Institute of Arbitrators, Fellowship and Chartered Arbitrator on those sorts of things, because my co-head of International Arbitration, Ben Giretta, would otherwise give me a hard time. So a shout out for them. Let's move on, because time is, as ever, our enemy. Kimberley, I was going to come to you. Now just talk about the improvements and looking forward and how we can get better. The ICC report made recommendations to improve the accuracy of witness memory and hence the quality of the evidence as presented. What's the psychology underlying those recommendations?
Yeah, there are numerous recommendations in the report under Section 5, and I won't try and outline all of them here, but they are recommendations for all parties involved, and there are even some for arbitrators. But just to give you a flavour of some of those recommendations, things that any interviewer can do, of course, is I think John already alluded to, is to interview people as quickly as possible to minimise the chance of contamination. The older a memory is, the more prone to suggestive influences it becomes. Establishing rapport is something we don't often think about, I think, in legal contexts, but actually building some rapport with a witness before you question them can have very substantial and good effects on the quantity and quality of the information they recall. And also asking witnesses to provide a free report without interruption as early on as possible, where they recall everything they can without being questioned, can actually first, it pushes them to rely on their natural memory mechanisms to recall information, which makes it easier for them to recall. But also it can actually protect them in the long term to some extent from other suggestive influences. So when they have to recall the event at a later point, at a hearing, for example, they are less likely to have their memory contaminated at that point. So there's also, people can learn more about what the cognitive interview is. This is a research-led interviewing technique, which has been largely developed for police interviews in the criminal context. But the principles behind the cognitive interview can be adopted in any situation where a witness is being questioned. And it involves simple things like asking the witness to mentally put themselves back in the situation to help cue their memory. Getting them to think about an event from a different perspective can help them again to remember more information. So there are actually things you can do to improve the quality and quantity that a witness recalls. And the ICC report does outline some of those things. I think the other important thing to do is actually to ask witnesses to consider the source of their memories, because sometimes they can accurately, when they are warned to think about it, they can accurately tell you, I know this information because it came to me in an email after the event, or, you know, I learned about it through a discussion. And so you can better gauge the accuracy of that information if it's important. By just asking them how they know that information. So those are some of the things, and they are all backed up by the scientific literature.
Kimberley, many thanks. John, I'm going to come to you because the Witness Evidence Working Group makes similar recommendations. Is it simply a case of stripping out the inadmissible evidence and improving the gathering process to improve the overall product at the end of the day?
No, that's the ambition's is slightly higher than that. I mean, the witness statements, even without it, the group coming into existence and the new rules coming into existence, it should never have contained inadmissible material in the first place, and should never have contained commentary and argument. So I think the aim was to go slightly beyond that, and at the risk of sounding rather pompous, to try and bring about a change of culture about how we approach witness evidence and witnesses, which has two main aims. One is to improve the quality of the evidence. The rules that the aim of the group and the rules was not, for example, to save money. It was a genuine attempt to try and improve the quality of the evidence that the courts have before them. And the second thing was to increase transparency about the process. And that it goes against the grain in some ways, because we tend to think of the process of collecting witness evidence and producing draft as something that goes on very much behind the closed curtains of the solicitor's office, that you as a judge, you don't get to look at where you started from, where you ended. But under the new rules, that's what you have to do. As the witness, you have to say when you were first asked to recall the events in question. You have to now say what documents you were shown or what stage, and how they changed your memory. Now, that process and the witness statement that is produced before the court in every witness statement since the 6th of April this year has to explain that process. And that is, we hope, an important discipline in itself, which will try and ensure that the witness's own memories are, as it were, treated with more kid gloves than they are under the old regime. That they're treated in some ways with more respect than they were previously. And so the main purpose is not just to change the rules slightly around how things are put together, but to recognise, as I said before, the malleability and the fragility of witness memory, and doing all the sorts of things that Kimberley's already referred to, such as ensuring there's one proof at an early stage. And because that proof is so important, I suspect that the importance of having a rapport with the witness, as Kimberley mentioned, will come almost automatically. If you know you've only got 2 shots at it, one shot is to get the proof. We hope, the idea of the rules is that we hope that will lead to a situation where the witness is allowed to speak with open questions, and isn't harassed by, well, here's 3 lever arch files of documents. Before you start recording the events, just read these documents first. That's something that the rules are intended to discourage, because no one's going to want to reveal that. In some ways, I think it is inevitably probably going to shift the balance of what happens at trials. Whereas before, to a certain extent, the set piece of the English commercial court action was the cross-examination of the main witness, putting your case, to the main witness, who is the person that's been put up to tell the entire story with all the cross-reference documents. That may well change, and we shift to a system actually that's a bit more like international arbitration, with a memorial-based opening submissions, and instead of the cross-examination being the set piece, it will be the opening and closing submissions, where you spend more time submitting to the tribunal why they should accept your narrative, your story, because it accords with the documents, and you spend less time cross-examining witnesses over the minutiae of whether they remember precisely X or Y, and whether it's compatible with what they said in an email sent on a particular day 7 years ago. So we're hoping that there's a bit more of a cultural shift than simply getting rid of the inadmissible evidence and changing some of the rules about how they're put together. But we'll see.
Thank you, John. And Lord Neuberger, finally, if I may come to you, you had an interval of some 14 years as an appellate judge between your career as a first instance judge hearing trials and now your career as arbitrator. What have you noticed has changed, and how much do you think is attributable to the difference between litigation and arbitration? And will the changes recommended by these 2 bodies achieve their intended aim? Huge questions, sorry.
No, it's all right. It's very difficult to compare arbitration with litigation for the reason you've given, that the last time I was involved in litigation as a judge was 14 years ago. So I'm comparing arbitration today with litigation 17 years ago or so. I think that certainly the detail and volume of witness statements has increased. I think that when it comes to arbitration, both examination in chief, i.e. what are now witness statements, and cross-examination range more widely than in court, because arbitrators are expected in practice to be more tolerant and less interventionist than judges, and generally they are. I think it's for at least two reasons. One is arbitrators are part of a consensual contractual arrangement and aren't performing a public duty and don't have a responsibility to ensure court time isn't taken up and so on like judges do. And secondly, if you're trying a case on your own, you can say with more confidence, I'm not finding it helpful, or where's it going, or interrupting a bit. Whereas if there are three of you, you can't be quite sure what your other two colleagues think. And the whole atmosphere anyway, probably a third reason connected with those two, is less conducive to arbitrators being more interventionist. But I think therefore I've noticed more evidence, more arguably irrelevant or peripheral evidence. I think in terms of where we're going, cross-examination is a questionable activity. If you're pointing out to a witness inconsistencies between what he says and inherent likelihood, or what she says and the documentation, then you can do that far more efficiently by pointing it out to the judge or the arbitrator. You don't need to go through cross-examination. And as for the rest of a good cross-examination, I'm afraid it can be said to be either a sign of a good cross-examiner or the sign of a bad witness. But you're not looking to see if the witness is a bad witness. You're looking to see if the witness is telling the truth, which isn't the same thing. So cross-examination, sometimes I accept, can produce the truth in a way that nothing else has. But often it's a very time-consuming and distracting way of establishing points which, as John said, could be established much more efficiently in submissions. When it comes to the sort of rules that have developed since I was in practice, when my practice initially was as a barrister was exclusively in the county courts, you were quite lucky sometimes if you had a proof at all, but you only had your own proof. You didn't know what the other side's witness were going to say. And we've been on a journey over 45 years of getting more and more prescriptive in terms of what can be done. I suspect, and I may be wrong, that this is all part of the pendulum effect, and we will get more and more prescriptive, and then eventually somebody will wake up and say this is all too prescriptive, all too rule-based. We've got to let things loosen a bit, and there'll be a tendency to go the other way. I may be wrong, and it may be that the sort of proposals that have been put forward by the working party John was on and now being implemented may represent an improvement. In my experience, the legal profession dislikes intensely any change and is very sniffy about it. And one shouldn't go on what they say, one should see how it works out. And it may be that my pendulum view, it turns out to be wrong, and this is an improvement and is a better way of getting to the truth. But I think we have to bear in mind always that what we're trying to do is to get at the truth in a way that respects people and in a way which minimizes cost as well. John was slightly hesitant on the question of cost, but I think we have to accept that, save in the very large commercial cases, which is, I appreciate what the rules he's concerned with are concentrating on, in other cases, one does have to keep an eye on proportionality. So where we go next, I'd be very interested to see if I live long enough.
Well, I'm sure and hope that you do. We've got a proposal from Singapore that they will advance, or potentially advance witness statements so that they come before disclosure of documents. Does anybody have any thoughts on that as to how that might get us any closer to the best evidence, if it's untrammeled by the documents that the other side have disclosed, or indeed your own side, perhaps?
Well,
John.
I can see that proposal would remove one temptation, which is to include in the witness statement a whole load of commentary on the other side's documents. But it's interesting that is not a proposal that came up actually. The witness evidence working group went out to the profession, and not just the profession, but to court users generally, including the arbitration world and arbitration practitioners, and said, well, what do you think? No one was particularly attracted by any of the more radical suggestions, such as going back to old-fashioned examination in chief. I mean, there was quite a lot of commercial court judges who were very keen on the idea of just saying, get rid of the witness statement, go back to examination in chief. It will shorten trials for sure, not least because you won't have it'd be a bit like going back to the county court. You won't have time for pair cross-examination because you haven't got a clue what the other side are going to say. That will, at a stroke, reduce the length of trials in the commercial court by about 50%. But other proposals that popped up, for example, a variation on Singapore, which is why not do the American thing? Depose the witnesses at a very early stage, get them in an office, put the video camera on, ask some questions, see how they look, and see how convincing they are. Again, that didn't really get didn't attract much support. So we ended up with actually, in some ways, quite a conservative set of rules, which is to largely try and get back to the core purpose of a witness statement, which was to put down in writing in advance the genuine examination in chief, what they could really say about a case that you really needed to say that you couldn't prove by documents. It could be it's a long answer to your short question. I can see some advantages to it, but I think as a standalone measure, it doesn't achieve very much.
Well, we're over time, but with the panel's indulgence, I'll just ask two questions. One, because I've just asked John something. One for Kimberley and one for Lord Neuberger. Can be a very interesting question on the chat about cross-examining and saying your recollection would have been better closer to the event. Is that a universal truth? And what about particularly traumatic events? Perhaps not that we would experience in our commercial lives, but does sometimes trauma need some healing time to be able to then to recount it properly?
Okay, well, the time issue first. So we know that memory drops off very quickly. Memory accuracy and quantity drops off very quickly immediately after an event has happened. So memory fades very fast immediately after an event, and then it sort of it levels off over time. So it is important to get in there and interview a witness as early as possible. Generally, that is the way memory goes, and we've known this for 100 years. In terms of trauma, it's complex. The research on stress, trauma, and memory and arousal is extremely complex. I did see the question in the chat, and it hints at the concept, I think, of repression, the fact that people may, well, I won't say fact because it's not a fact, this idea that people may actually, bury away a traumatic memory and it's later on unleashed by some appropriate cue in their environment. What we know is that traumatic memories actually tend to be remembered better than non-traumatic events, and that they are more likely to be persistent in memory and very detailed and coherent. And so, but it is a complex area of study, trauma and memory. And there is some disagreement amongst memory experts on that. So hopefully, I don't know if I've answered the question from the audience member, but I'd be happy actually to talk to them further about the research on that if they would like to contact me.
Thank you. And a final question from the chat, Lord Neuberger, if I may. Tips for advocates to try and politely remind a tribunal that of some of the work that's gone into these two reports. How might an advocate politely tell a tribunal, look, you may be subject to all sorts of biases, and just remember that in your decision making?
I think that's a very good question. Picking up something John Kimbell said, you've got, to some extent, I'm afraid, when it comes to a tribunal, to play the man, not the ball. And some judges do not take offense very easily, and others, whether a man or a woman, sometimes have to be handled more carefully. I would hope that to tell a judge, particularly a judge who's now had judicial education, would be more ready to listen to the point that judicial bias was there, because he or she will have been told that and will have been trained about it. I think it depends what the issue is. It's quite difficult with your client sitting behind you to say, look, I'm aware that my client came across as an extremely untrustworthy, dislikable individual, a bully and a rogue, but his basic story when it came to this, this, and this fitted the documents, and that's far more important. But with your client sitting behind you and paying your fee, it's a little difficult to put it like that, depending again on the client. But I think most judges, if they're worthy of their position, should be perfectly ready to be reminded about bias, but do it tactfully. Don't say you are biased, but mention that, I don't know, when I was listening to the evidence, I was conscious that I was thinking this, and just in case your lordship was too, then may I suggest that, or during my learned friend submissions, the thought occurred to me such and such, and I may have occurred to your ladyship as well, and if it did, then so on. Something like that, perhaps, i.e. putting yourself in the same position, so they can't really say it's an insult because you'd be insulting yourself. But I'm sure the advocates in the room are far more experienced at advocacy than I am. I'm thoroughly stale, but those are a few ideas. I expect John has some much better ones, but he may not want to give away the tricks of his trade.
I agree with that. I think it's very hard, and almost the first rule of advocacy is know your judge. It's what we all do in chambers. We get a new judge and we send them an email, any tips, and you gather all the intelligence you can. And there are some judges that will really not be receptive. So a light touch, but in an appropriate case, it may well be exactly the right thing to do.
Yeah, you don't want your GDPR people to tell you about those emails, I tell you, but that may be another problem, waiting. We always do all that orally, just to avoid those potential issues. Well, we are now quite a bit over time, so my thanks to the panel, Dr. Kimberley Wade, John Kimbell QC, Lord Neuberger. It is recorded, it will be available on the Fox Williams website, and no doubt will find its way to other places. My thanks to everybody, and stay safe and stay well.